So this next question is all about, should I file my own patents or should I hire somebody to file my patents? Should I retain counsel, a patent prosecutor, to do it for me? And, there's, just like in court, you can represent yourself. You can represent yourself in front of the patent office. And I heard this once, this expression that the person that represents themselves has a fool for a client. And, I'm not going to say that that's 1,000% sure, but it's probably 95% sure. And that I've seen people that may have lots of experience in there and they've done it before, or they may have internal counsel that helps them with this. Maybe it's somebody that worked at a firm. In those circumstances, you can have somebody who's competent at doing it. It's really hard to keep up on the law and the trends to know what strategies make sense and don't make sense. But what I find with my clients is most of the people in the electronic software space, the tech space, they almost always will use outside counsel. Sometimes in the life sciences area, they'll hire their own experts that will sometimes write patents. They tend to be very complex and involved, and the expertise required is very specific. And finding somebody maybe at a firm that has that same expertise might be difficult. And those patents tend to be much more valuable. For example, for a drug formulation, that patent may be worth billions and billions of dollars. So getting it right, you may not want to leave that to chance that some service provider can do that for you. Sometimes it'll be a collaboration. I do that fairly often. Well, I'll work with a company and maybe I'll review it, make sure that it's in shape to do. Sometimes you're saving money on that. Sometimes you're not, because my review is costly too. 95% true, the answer is you should hire outside counsel. And especially writing claims it's an arcane sort of, if you've ever read any patent claims, they're kind of indecipherable to the layperson. And that's where just a simple word, use this word rather than that word. And if you look it up in the thesaurus, they're equivalent, but there could be a case that interprets this word differently than that word. So pretty quickly, it becomes really important to hire counsel. Sometimes where it's just absolutely not possible. You just don't have the money. There's no way to raise the money. And then I question whether or not a patent really makes sense. You might be able to just compete in the marketplace some other way, sell it cheaper, find a cheaper way to manufacture it, maybe move faster than a competitor. Patents tend to be for things that are going to scale big because the costs involved with the patent just don't make sense. I once had a pro bono client that had an item that sold for 35 cents. And she came to me, and pro bono, you might do that work, and still we don't cover the government fees. So the government fees on a patent can be 5 figures. And then I went through the analysis. It's like, look, that 30-cent item that you're selling, how much more do you have to sell it for to cover that $10,000 cost? And the answer was it was going to have to sell for 75 cents because of the volumes that she was talking about. At least in the near term, it was going to have to sell for 75 cents. And at that price, there's no way she could get any sort of market penetration. So, a patent application, I just wrote a paper on this topic, a patent application in the software area, by the time you pay to have it written, argue it through the patent office, pay the government fees, you realize that you have to file 3 patents to get 2, so there's kind of this yield concept in there. There's also burden on your innovators, right? They've got to spend time reviewing it. There might be an inventor bonus program. But as I went through kind of a pretty vanilla calculation, taking all those things into account, the number I came up with was $80,000 is what it was, the cost to the enterprise if you had to put a price on it. So there's very few things that warrant $80,000 worth of protection, right? You could probably get a pretty neat bank vault for that kind of money. But you know, if what you're putting in that vault is very valuable and that's what you have to do. And it's not uncommon for a particular product to have several patents on it. So, you know, large enterprises will spend a lot of money on their patents. And it could be that that patent not just protects that product, but it may protect a whole product line, you know, a whole platform that develops around that technology. So the economics can make sense. But know that when you go and talk to a patent attorney, the economics always make sense for them because they charge by the hour and they start making money the moment you show up. So their interests are not necessarily aligned with yours. So when you're working with any vendor, understand how they get paid and understand how that may taint their advice. So when they recommend that you go forward and they really like this idea, well, do they like it because it's going to help you be successful, or do they like it because it's going to help their firm be successful? And I always have that tough conversation with my small clients. The big clients have already figured it out. They know it. They know whether or not patents make sense or not. But with the small clients, we all go through those numbers. And we talk about timing, we talk about likelihood of success, and we talk about costs. So up front, people are going into it eyes open. And of course, patents can be very powerful and very valuable over time, and it might be some of the most important assets in your enterprise. But pause before you and look over the edge of that decision before you jump in and don't have as much opportunity to take a different course of action. So I hope that answers the question. If it didn't, put something in comments below, and don't forget to like and subscribe. Thank you.